texting or any communication of any type.
Yes, Your Honor. I understand.
You understand that through no electronic means whatsoever, meaning your use of the internet or anything like that, are you to refer to her in any way? You understand that?
Yes, Your Honor.
And you are not to try to communicate with her in any way. So understand that.
Yes, Your Honor.
You understand that that also applies to your family members.
Yes, Your Honor.
And that you would be directing them not to do that.
Yes, Your Honor.
And that if the court were to find that there was that type of third-party communication, you would explain to them that your liberty is in jeopardy. You understand that?
Good morning, Your Honor. Robert Ellman on behalf of Miss Olive in case number ending in 1321. Your Honor, Mr. Kolovos was here. He is representing Miss Olive on the other case. However, I was informed this morning that he is taking over my case as well. I believe he filed an appearance. He has asked me to stand in on these matters.
Well, he'd have to file a substitution, first of all.
I understand, Your Honor.
Okay.
I'm working with what I have here.
It's pretty much the call of my given day or any day for me.
So
All right. So you're looking for an adjournment.
I know that I had Mr. Kolovos fill out a couple of green sheets. I believe you have those in both files.
Did have the green sheets.
Yeah.
Mr. Clovis was here.
Where'd he go?
He indicated. I told him if he
He had to go someplace else. The judge would be upset if he didn't go there.
correct,
So what am I supposed to do?
apparently not
I'm-
upset.
I'm kind of inconsiderate judge.
Your Honor, on
I'm
behalf
to change that whole.
on behalf
I'm-
of Miss Olive, I'm here and I'm happy to see.
No, I'm not. Miss Alat, you understand, what's his name? Clovis?
Kolovos?
He's gonna be representing you on both matters? Is that your understanding? All right, do you have any, for the purposes of an adjournment today, do you have any objection to Mr. Allman stepping in?
No, sir.
All right, thank you. All right. Did he indicate to you as he headed off to the other judge that he likes more? How much time he'd need?
No, Your Honor. I believe maybe sometime in an early May date, maybe mid-May would be fine. I don't know.
Your Honor, I spoke with Mr. Kolovos this morning, certainly don't want to put words in my mouth. I think that we're getting pretty close to a waiver being disputed here between the city.
Sorry. Are these the only cases holding you, young lady?
Yes, sir.
Are you still being?
That,
Let me double check, and I believe she has
I'm done with
probationary matter.
oh, she's serving time on probation violation. All right, then I'll adjourn it to May 7th.
Thank you, Your Honor.
Both matters. 26:09 a.m. All right.
Thank you, Your Honor. That's it for me. Have a good day. That's it.
Here, nothing. No, I'm kidding.
I could have left with Mr. Kolovos, Your Honor.
Yeah, I got a way of getting you back.
It's
But
good.
anyway, never mind. All right, thank you. Have a good day. Court, that's called the case of the people versus Sebastian Phillips.
Kennedy for the people, Your Honor.
Good morning, Rob J. Columbia. Name Sebastian.
Sebastian.
Judge, I know my client is anxious to get this case going. However, we still don't have the report from.
Pardon?
We don't have the competency report yet, Your Honor.
We do. I have a copy of it. CFP. We got the competency report. He's talking about. I guess
On this case, I don't have it.
we have an ATO with Darlene O'Brien that he's saying that we could use for competency referral to go to Kalamazoo Psychiatric Hospital until I'm being competent. That's what he was trying to indicate. But
Judge, can we adjourn this out a couple weeks?
can I make a statement?
And I don't have one.
I have it right here. I have a copy of it.
From the forensics?
Yeah, from the forensics. It's to Judge Simpson.
Is that the report that says you're incompetent?
Yeah. Are you not referring to that?
That's, we're waiting for you to gain competency. We know about.
No, of the incompetency report.
Yeah.
The other report or a review of that report, correct?
Correct.
And that report, Mr. Phillips, you don't have.
I thought, see, he's not being clear and concise with me.
Who's not?
My attorney.
Oh, Mr. Kilowald is one of the most.
I know he's
Like,
good.
I know.
I'm just saying that we're having some clear issues with being clear and concise on the specific.
Well, here,
of-
let me be clear and concise. There was a report that found you incompetent.
Right.
I do not have any other follow-up report. Mr. Kennedy has indicated the people do not, and Mr. Kilowald has indicated he does not
Okay.
follow-up report.
Okay. I wasn't.
So all I can do is adjourn the matter
Oh.
so we can get a follow-up report.
So are you referring to a referral to a CFP facility? Is that what you're indicating?
I'm not referring to anything. The only thing I'm referring to is I don't have a report.
Yeah, so what I'm trying to understand, because I don't understand, is if we have the CFP report, then need an additional document, is what you're saying? In order for me to be
Mr. Phillips, there's a
Yes.
report that says you're incompetent right now, but restorable. We're
Right.
waiting for that. You and I discussed on the matter and the other matter, if you want to go to the psychiatric hospital in Kalamazoo, that if you think that'll help restore you, that we shouldn't confuse the two cases. In this case, Judge Simpson does not have a report that says you're competent. I'm asking this to adjourn us out 30 days.
Yeah, so what I wanted to say is that oh my God. Would it be IST? Incompetent to stand trial? Would that be an order that needs to be? Because we're trying to figure out if I'm deemed incompetent, where am I going to be? Because they said that they can't. Community mental health said that they can't.
You have to work that through with your attorney. The order finding you incompetent, that has already happened.
Yeah.
I'm just looking for a review of that.
Oh. Oh, sorry.
Mr. Phillips, let's just get the 30-day adjournment. If the judge will grant that, I will deal with the other matter, see if we can get a referral order.
I will adjourn the competence hearing to May
I'm sorry, Judge, what was that?
28th, 2026, 9 a.m. Defendant's bond will kick.
Okay.
Thank you, Jeff.
Yeah.
I'm gonna explain it.
Oh.
Give me a call.
Okay.
Court calls the case People versus Joshua Hillsburg.
People, Your Honor.
Robert, on behalf of Mr. Hillsburg, who is coming out to join us as we speak.
Your name?
Joshua Hillsburg.
All right, what are we doing?
Thank you, Judge. Your Honor, Mr. Hillsburg is being arraigned on an additional charge this afternoon. So we are asking for an adjournment so they can catch up.
One with him. Did we give a date that they're gonna try to set his other cases? We were gonna give them the date. So how much time did you want? You want 2 weeks out or 3?
There is, in relation to that, there's some additional media I'm expecting, along with some supplement reports.
So we got this one.
So it may
Very simple. Yeah, I mean,
2 or 3 work.
I'd ask for the shortest side.
Well, I also want to make sure that you're gonna get the additional media, because otherwise we're gonna get here and then we're gonna ask for an adjournment, but if you want the shortest time, I'll give it to you. Shortest time, May 7th. Hope we have everything. May 7th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Much.
Okay.
Court calls case People versus Going Robinson.
And good morning, Your Honor. Assistant Public Defender, Mazize Kernie on behalf of Mr. Glenn Robinson on the 1556 now.
Morning, Honor. Robert J. Cole, Judge. I have case 2330.
Your name, sir? Owen Robinson. Thank you, sir.
Judge, I met with Ms.
Great to see you, Ms. Ackerman. I was at a conference and somebody asked specifically about you and how you were doing.
Oh. I
I gave them my report.
That's it. Great things, Judge.
Okay.
Judge,
What are we doing?
Mr. Robertson and I met in my office. At this point, he wants to set it for exam.
And on your matter?
The same, Your Honor. We'd like to set it the preliminary exam.
All right. Discovery is all complete on both cases.
Yes, Your Honor.
Yes.
Would the people have their witnesses available the 5th? Preliminary examination in this matter will, in both cases, will be set for May 5th, 2026, 9 a.m. before Judge Fresh Hour at 10 a.m. on the 5th.
10 a.m. Okay. Thank you, Your Honor.
Thank you, Judge.
I'll talk to you beforehand, okay? Be good.
Court does call the cases of the people versus Cheedra.
Your Honor, ready.
Assistant Public Defender J. John, on behalf of KG on all matters not ending in 1678, Your Honor.
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji on his other matter. And he is coming from.
He's actually right behind you.
Oh.
Right behind. Oh, sorry. Thank you. All right. Waving.
Your Honor, yes, he is waiving, and we have an agreement to be placed on the record. And after his waiver of the prelim, we'd like to address bond, please.
And Your Honor, that's accurate. It's a bit of a long agreement, but I guess with counsel's permission, I'll put a brief version. He's going to be waiving up on the 3 non-CSC cases. He'll be pleading to misdemeanors under HIDA in circuit court, with the idea being to keep the probation all in one place. Felony misdemeanors on those cases. I'll need Mr. Kenneth to outline the plea of release to the CSC matter.
Yes, someone else with that matter, Your Honor. Bond over 64 to 1360.
Is that a correct statement?
It is, Your Honor.
It is, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand all of these matters. You understand that a preliminary examination is where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand.
You understand that in all of these cases, you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
The people on all of these matters also waive their right to preliminary examination.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on 1, 2, 3. One, 2, 4. Just trying to make sure I have all of the counts. On all 6, 1, 2, 3, 4, 5, 6, 7, 8 felonies, he's waiving, and followed by the 1 misdemeanor.
Correct, Your Honor. As to that, we would waive formal reading, stand mute, acknowledge receipt of the information.
Us to Your Honor on case number 1678.
Defendant having waived formal reading, standing mute. On all of the cases, court will enter not guilty plea as to all charges. Pretrial in these matters will be set for
May 12th at 1:30 with Judge Combmes.
May 12, 2026, 1:30 for Judge Combmes. Esteban.
Thank you, Your Honor. Mr. Ikeji has been in, he's now approaching 200 days. The original bond that placed him in jail became reasonable based on mental health issues that culminated in a new arrest upon the same day as an initial release. That obviously was a unfortunate set of circumstances that resulted in a series of mental health evaluations, new treatments, competency and not guilty, but and insanity evaluations. The result of that now is he's been on new medication for a number of months now. Mr. Bellamy and I have both seen he's basically a different person since that started up. The Forensic Center noted the same thing on their evaluation that recommended or that concluded not guilty by reason of insanity. We have confidence now that with home confinement, he's going to do really well. His father is here today. He would stay with his father. His mother could not be here today because of work, but she has been at every other court proceeding. Mr. Ikeji has graduated from New York University. He has no criminal record beyond this series of arrests that were all part of the same connected mental health crisis. He's an extraordinarily promising young man. I look forward to his success down the road. And we're simply asking that close to 200 days is more time of incarceration than he is absolutely going to receive once these pleas are implemented. So we would ask that you consider a shift to home confinement today.
Response from the people.
Your Honor, people are fine. So by fidelity, it's also after the defendant, that condition of defendant's not apply with any worse for CMH as well as in prescribing drugs of medication.
Any other response from the people?
No, Your
No, I would just echo what Mr.
So you have no objection to a PR home confinement in compliance with CMH?
Honor.
All right, I don't have a problem ordering that then if everybody's in agreement. However, I'm going to need an order to that effect.
We'll get that for you, Your Honor.
And it's a home confinement tether, correct?
Yes.
All right. Well, I'll need the order because these files will otherwise be going up and then it'd have to be signed to somebody else, but
We'll get that to you today, Your Honor.
okay, thank you.
Thank you, Judge.
So we'll keep your date. Okay.
Thank you, Your Honor. Stop me like that.
You're gonna have to. Right, you're gonna also have to, something with this bond order, they're gonna need to prepare an order for me if they're gonna.
Okay.
I need to know that, but I wanted to make sure all this paperwork. And then I don't have. Counsel on these, will prepare them for your signature of the informations. However, I do not have all of the, I only have 2 of the information. So you have to check with my staff to figure out which ones you need to print and get to us.
Yeah, understood. Thank you.
Well,
Thank you.
Yes.
No, good chance.
I'm gonna have this bond continued because
Absolutely.
otherwise,
So before it comes.
yeah, I've got 2 of the information. Court does call the case People versus Diamond White.
People, Your Honor.
Morning, I'm Rob Jacob on behalf of Diamond White. Your Honor,
Diamond Light.
Thank you.
I'm sorry, I have a green sheet. When we adjourn this a couple weeks, who's the point?
On the other side of this.
Pardon me?
And then I have people.
Thank you. I didn't hear, so. All right, you want to do what?
I was just appointed if we could adjourn this a couple weeks.
Have a green sheet?
Yes.
How much time did you need?
Couple weeks.
Probable cause conference will be adjourned May 7, 2026, 9 a.m. Bond.
You know that. You're not the same.
Thank you.
Certainly. Yeah. Yeah. All right, thanks, Judge.
Court calls the case People versus Santis, Alat.
Assistant Public Defender Chenazi Carey, I can rule Your Honor on behalf of Mr. Alat. Mr. Alat.
Sir, solid seat. Thank you.
Your Honor, we are asking that this matter be set for preliminary examination. We'd also like to address a bond request.
I have a bond request.
Your Judge.
He's out.
Yes, we'd like to keep
Okay,
that one.
messed this up, aren't you?
No,
Would you have all discovery?
to our knowledge, Judge, yes.
People have their witnesses available the fifth?
Try for that date, Your Honor.
Oh, that's okay. Preliminary examination will be set May 5th, 2026, 9 a.m. That is before
Judge Perry.
Judge Perry. Yes, that's the bond.
As to bond, Judge, Mr. Alateef indicates that he has a wedding that is scheduled for June the 24th to.
Not his.
Not his wedding, Judge, no.
Nobody needs to be there.
Nobody needs to be there.
It's gonna happen.
Mexico.
Go ahead.
It's in Cancun, Mexico. And yeah.
Go ahead.
So we're asking for permission to allow him to travel for that time period to the
What's the time period?
June the 24th to return on the 30th.
It's a long wedding.
I know, Judge.
Any objection from the people, please? Really? No.
Let's just test and get it down.
I will allow the defendant to travel to Cancun. Those include your travel dates, sir?
Yes, sir.
June 24th to June 30th. He can travel to Mexico.
Thank you.
I would indicate that immediately upon your return, June 30th is the meeting. So you are to report to July 1st, 9 a.m. to Community Corrections for take needs. Okay.
All right.
All right. Thank you.
Full panel with an ECG, Your Honor.
Yes, full panel with it.
Okay.
Yeah. We'll prepare that one.
Thank you so much, Judge.
Thank you. Court does call the case, People versus Kelly, Joe. Well.
Good morning, Your Honor. Edward Drukas on behalf of the defendant.
Oh, good morning, Mr. Jervis. All right.
Good morning.
Your name?
Kelly Group.
All right. You're asking for an adjournment, sir?
Yep, for the purpose that's stated on the green sheet.
All right. 2 weeks. Will 2 weeks do for you? Or
2 weeks can work. I have the submission form for the recovery court I was going to turn in, but it may take a little longer than 2 weeks.
longer than that? Yeah. Okay. Why don't I do the 14th? Let's see where we are. Okay.
Sounds good. Thank you, Your Honor.
All right. I'll adjourn to May 14th, ma'am. All right. 9 a.m. Bond continued. Thank you. Court calls case, People versus Jennifer Baker.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who appears via Zoom. Ms. Baker, can you please unmute yourself and state your name for the record, please?
Yes, Jennifer Lynn Baker.
Your Honor, I'm just taking a little more time. We're in the middle of negotiations on this.
7th work or the 14th?
7th is just fine.
Adjourn the matter to May 7th,
Thank you.
2026, 9 a.m.
Thank you, Your Honor.
Thank you, ma'am.
Thank you.
Court calls the case, People versus Connor Kearns.
Then I'm here for people, Your Honor.
Morning, Your Honor. Richard Lippin on behalf of the defendant, Mr. Kearns, who's approaching the podium. Your Honor, in regards to the probable cause conference, I spoke with the prosecutor. I believe that we're going to try and resolve this matter by seeing if Mr. Kearns would qualify to get into Veterans Court. He needs to be screened at before it happened. For that reason, I'm asking that we have a new PC for May 21st.
21st, okay, that'll be fine. Probable cause conference, I'll adjourn to May 21st, 2026.
Thank you, Your Honor. Now, on a separate matter, Your Honor, I'd like to make an oral motion regarding bond.
No, go ahead.
Your Honor, the court is well versed in this case, having spent an inordinate amount of time on it earlier this week. Mr. Kearns is the first time this is his first criminal matter of any sort in his life. He's 31 years old. This has been a sobering experience for him the last 72 hours. I think that he has a greater understanding of the seriousness of the orders of this court. We're asking that the court consider releasing him at this time to home confinement, work, school, court, those types of things. If the court is inclined to give him home confinement, we would also ask that he be allowed to go to the YMCA. He tells me that the victim is not a member of the YMCA, does not belong to that YMCA. And so that would be our prayer, Your Honor.
In Ann Arbor?
Which YMCA? I think in Dexter.
In Dexter.
In Dexter.
Dexter. Response from the people.
I would not have been released on the home confinement with other hours for work and school. Yeah.
All right. What I will do is I will grant defendant's request. I'll reinstate his previous bond amount. He will be released. He will have to report. Actually, I want a GPS on him prior to his release. That would be a home confinement. GPS tether with releases to school and work only, and the YMCA only.
Is that an order that I need to prepare, Your Honor?
We will prepare. I have the order reinstating his previous bond.
Great.
To the community corrections order, we'll prepare that.
Great. So I don't need to upload any.
No.
Great.
You got it.
Then, Your Honor, if I could just quickly voir dire the defendant for one quick second. What happens if the victim shows up at your house? What do you do?
I'll call the police.
Okay. What do you do if you see her anywhere?
Call the police.
Okay. You don't speak to her. You don't do anything. You understand?
I understand.
Okay.
You understand, sir, because of what was in this, that includes texting or any communication of any type.
Yes, Your Honor. I understand.
You understand that through no electronic means whatsoever, meaning your use of the internet or anything like that. Are you to refer to her in any way? You understand that?
Yes, Your Honor.
And you are not to try to communicate with her in any way. So understand that.
Yes, Your Honor.
You understand that also applies to your family members.
Yes, Your Honor.
And that you would be directing them not to do that.
Yes, Your Honor.
And that if court were to find that there was that type of third-party communication, you would explain to them that your liberty is in jeopardy. You understand that, sir?
Yes, Your Honor.
All right. Very good.
Thank you very much, Your Honor. Thank you for your time on this matter.
No problem. Thank you, counsel.
Thank you, Your Honor.
And counsel, on Where did he leave already? He bolted. Can you just check? And I need counsel to approach on that last one. Went into a side room.
Looking from me.
Court does call the case People versus Maurice Boyd.
Phillips for the people.
Assistant Public Defender Santiz Carey, I will, Your Honor, on behalf of Mr. Maurice Boyd, who's in on zone, Judge.
I'm walking to the phone. Okay. Mr. Boyd, can you state his name, please?
Maurice Deshaun Boyd.
Thank you, sir.
You're welcome.
Judge, we're asking for an adjournment to put together some mitigation for Mr.
Matter 14, 2026.
Thank you, Judge.
Thank you. God bless.
And to you, sir. Court does call the case People versus Jason Haidu Banks.
Then we have.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbst with and on behalf of Mr. Haidu Banks, who's up
Really?
in the podium.
You were there all morning.
I know it's about time.
There's something gotten up.
I know.
Oh. Your phone give you a lot?
Your Honor, I have quite a few cases actually. It's just they're all at the end, toward the end of the alphabet of your block.
Got it. Okay, understood. Your name, sir?
Jason Oscar Haidu Banks.
Thank you.
Your Honor, we're requesting about a 2-week adjournment. Mr. Haidu Banks has informed me that him and his family are working on retaining Allison Krieger, and she just needs a few weeks to get that ironed out, and hopefully she'll be prepared to proceed by the next.
2 weeks, you think?
I believe that should be enough.
Yeah, 10 days or 2 weeks should be good enough, sir.
Okay.
Yes, Your Honor.
So I will adjourn it out to May 7th, 2026, 9 a.m. That's the only adjournment you'll get for that purpose, sir.
Thank you, Your Honor. Muchly appreciated.
All right.
Your Honor.
Okay. Court does call the case People versus Glenn Bradford.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Bradford, who approaches with Glenn Bradford.
Do I have before me a plea sheet that indicates that the defendant would be pleading to count 2 of violence upon a successful plea to that charge, the 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. And there is a sentence agreement to sentence under 7694A.
That's my understanding as well, Your Honor.
All right, very good. Let's have him sworn.
Raise your right hand. You solemnly swear in the affirmative testimony you're about to give will be the truth, the whole truth, but the truth so help you God.
Yes, I do.
State your name.
Glenn Bradford.
Sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
All right. Understand also, sir, that while I'm taking, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B.
Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Your Honor.
Question regarding any of those rights?
None.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do, Your Honor.
You understand you're giving up your right to appeal of right.
Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
And also because you believe that you're indeed guilty of this offense, sir?
Your Honor.
date of August 7th, 2025, at the location of 1043 East Forest Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do on that date involving a Gabriella Bradford that makes you think that you're guilty?
Gabrielle.
Gabriella
would be my daughter.
your daughter. Okay.
Me and my wife had an argument and I shoved her.
Okay. What's your wife's name?
Gabrielle Bradford.
Gabrielle Bradford. Okay.
The E at the end.
Got it. I see it. All right. And you shoved her. You did that on purpose, sir?
Yes.
You didn't have her permission to do that?
I didn't. No, Your Honor.
And as you've been your spouse. Sir, if I accept your plea, that you commit misconduct as defined by the Michigan court rules between the time that I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea. You understand that, sir?
Your Honor.
And the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be June 1st, 2026, 10 a.m. before Judge Washington.
So
bond with its conditions will continue.
as soon as possible. I just
See, I told you.
prosecutor and we'll get it to Judge Washington. Okay. Right. Okay. See that. Call me if you have any questions.
Do it. Just you just need to have more faith in people.
That Judy did.
Oh, well, maybe not. No, June 1st. Court calls the case, People versus Matthew King.
And then we got the people.
It's just everything in it.
Good morning. Joy Gaines, your Assistant Public Defender, representing Mr. King, who's present to my right. Would you please state your name, sir?
Antonio Kane. How you doing, Mr. Simpson?
I'm doing great, Mr. King. How are you? Good. All right. What are we doing?
Your Honor, we do not have discovery yet as of yesterday when I met with Mr. King. Miss Sunday, I'm assuming, because I emailed her at the same time regarding his as the other clients, that we will have it. Regardless, Mr. King wants to schedule the preliminary examination. And he is very much aware of where we are in this process. He is adamant that he wants to schedule the preliminary exam.
So Your Honor, at this point, I would be objecting to that, given that I have come to find out there is more discovery. There's a second venue involved in this case that does have additional video surveillance of the actual assault that occurred in this case. Further, there's going to be more discovery because I was planning to address bond today. So there will be jail calls that could be leading to other charges in relation to this case. So at this time, there are a few things in play here that I do not have yet and that defense does not have yet that I think would be very important for this case, along with another follow-up interview with the victim of this case as well.
My client still wishes to go forward with the preliminary exam as soon as possible.
Understands that if all of that's not there, or if we start the preliminary examination, that it could be adjourned if the people aren't entirely ready to go.
That's fine.
Pardon?
He said that's fine, Your Honor.
Been to jail 2 weeks. I ain't did nothing wrong. They always try to do.
Well, Miss King, let me just explain to you though, the problem's going to be you may be in there longer, sad, and nobody can go because they don't have the stuff and your counsel can't even advise you as to what you need to do. I mean, so that's all I'm saying.
Mr. Simpson, can I say something to him?
Well, I was going to say, I know that you and I talked about that and you understand that. And you are anxious to get this case moving forward.
Yes, I get none of these days credited. I've been in jail.
Well, sir, I don't.
No, he's on a parole hold.
Okay.
I thought he was lying.
Here's what I'm gonna do. The discovery that you have now, you can get over to,
It was sent yesterday, Your Honor.
it was sent yesterday.
Currently, it was sent over yesterday. I'm awaiting further subs along with that surveillance video from where the actual assault occurred. And then, potentially, and then Ms. Gaines would also get the jail calls, that could be leading to future charges as well.
As to the witnesses currently charged, you would at least have police officers that could testify, correct? Because I'm gonna do something with the date because everybody seems to be in a hurry. So I'm gonna set an in-person preliminary examination. I'm gonna set it for April 28th, 2026, a few days. Hang on. 9 a.m. That's before me.
Right. Thank you.
As the bond.
Your Honor, it's come to my attention that since being arraigned, Mr. King has been making calls to his family, that includes his sisters, I believe his mother. In these calls, he says, my son don't need to come to court, man. You don't need to come. Talk to his mama. You're right there. If you want to help your nephew, you need to get on that phone and talk to his mama. That's what I said. It's going to kill him in the end. She's supposed to be on it. So I would know what I would do. And further things telling them they need to talk to the victim's mother. The victim is his minor son. So he's asking them to talk to the victim's mother to try and get him to not come to court and to guilt him into coming to testify against his father. So I suspect this could be leading to future charges of witness interfering in the future. And we've not had a chance to go through all of the jail calls. These are just a few that occurred after arraignment. And Mr. King is also on parole for a witness intimidation interfering case as well.
Okay.
Your Honor, Mr. King did indicate to me that because this involves a family situation, that he had spoken to his mother and his sister. He has not spoken to his son or his son's mother, but his own mother. And everyone is aware of the allegations. He indicated that he does, to me, he indicated that he does have concerns about his son having to come in and testify and amplifying any potential issues between them. But he said to me when we were discussing that I did not have the discovery when I spoke with him yesterday, that he is prepared for his son to come and testify. So without more context, I think there may be more context than the statements alone are giving at this time. So the preliminary exam is April 28th. I know that you typically cease phone calls. I just want to reiterate that he has not had any phone calls with his son or his son's mother, but the exam is on
directing people to contact them. Same.
Well, I
cannot have only direct contact, Ms. Gaines. As you know, he can't have indirect contact.
Correct. I'm not disagreeing with that. I'm just saying that based on our in terms of there may be more that we may not be getting the whole conversation in context, given how he told me the conversations with his family went.
All right. What I will do is I'm going to read the people's request. The defendant's phone privileges and texting privileges are hereby ordered revoked. Sir, do not do that.
You always take my phone. I haven't did anything wrong, Mr. Sir. I haven't did anything wrong.
Want a hearing on it? Because I'll have to listen.
Let's do a hearing today.
Want me?
Because I need to talk to my family. I have things going on.
Sir,
Mr.
I want to do one today. Like you taking my phone, Mr. Simpson, and I ain't called them. The thing was, don't talk to my son. I haven't talked to him. I haven't contacted none of them.
Bond conditions were that you cannot have third-party contact or direct third-party.
I haven't.
Okay,
I haven't.
are you going to listen to me? Because if you're not going to listen to me, then I'm not going to listen to you. Okay, you can shake your head all you want. I'm just going to leave it there. We'll see you on Tuesday. You know, you respect me, I'll respect you, but I'm not going to do it. Yeah, we're gone. We're done. Court calls the case. People versus Denina Combmes.
You, if you're on that.
Yeah.
That's also good people.
Okay, where we are on behalf of the Denina Combmes.
Yeah, it's me.
Hello, what's your name?
Denina Combmes.
Okay. What are we doing?
Yes, we do have a
Deck of cards. Go ahead.
judge. You're asking for an adjournment. We're trying to establish contact with Ms. Combmes so that we can review the report with her, judge.
Probable cause conference will be adjourned then to May 7th. Ms. Combmes?
Yes.
You need to contact the public defender's office. You have their number?
I believe it's 222. Hold on. I think I just dialed it.
222-6970.
Yeah, I called them today, and I
called
thought I talked
them.
to them yesterday.
Just listen.
I mean,
You need to call them, make sure they have a good phone number and email address for you so that they can contact you and go through what's the matter with you, okay?
Okay.
All right, I'm adjourning your matter out a couple weeks to the 7th, 9 a.m.
Okay.
Okay?
Okay, thank you.
Thank you, Judge.
Bond will continue. Thank you. Court calls case People versus Kenneth Mazize.
Focus for the people.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Mays.
Morning. I'm Mr. Al. Good morning. What's your name, sir?
Kenneth May.
Thank you. What's he doing?
I don't know.
Tell him to stop. It was better when he was in that little box.
Aw.
I know. That's so true. All right. What are we doing on this?
So first of all, Your Honor, this matter was adjourned to today so that Mr. Mays could determine if wanted to have a hearing on the bond violation or if he or did not want to have a hearing. At this time, he is not asking for a hearing. He's asking that the court find his admissions to having used be sufficient, and is also asking for immediate sentencing to, I believe he has 8 days credit with credit for 8 days served, to 8 days with credit for 8 days served, and that his bond be reinstated. Yes, so he can return to work. He does have a good job at a warehouse at Haggerty, of course. I think that's Canton, but I'm not quite sure.
I'm sorry?
I think Haggerty and Ecorse is Canton, but I'm not sure.
Okay. Your response from the people.
Your Honor, I think the last time we were here, the defendant admitted to that he had used things before he was arrested. I don't recall a specific admission to things while he was on bond. So I just wanted to make sure the record was clear as to that. I think he was saying he wasn't sure how the amphetamines were in his system on April the 16th. So once the admission is on the record, I have no opposition to him getting credit for time served and being placed back up on.
He's
He's admitting to that at this.
Okay, to the use of the amphetamine after the point he was placed on.
That's correct.
Yes, sir.
So what I'm gonna do. So what are we doing with the case itself?
We still gonna set this for preliminary. Is that correct?
Oh, no.
Okay. Your Honor, may we have an adjournment? I will fill out a green sheet so that we can see if we're going to be able to work something out. Our conversation focused mostly on violations.
I got you. So I'll adjourn this out, sir, to May 7th, 2026, 9/8. What I will do is I will accept the defendant in the violation. I'll sentence him to 8 days in jail, credit 8 days served. I will indicate that his previous bond is reinstated with all conditions, including testing. So you're gonna go back on testing. You understand that?
Yes, sir. I do.
Now we're real clear what happens if it shows up dirty.
Yes, we are.
I'm crystal clear, right? Okay, I got you. Okay.
All right, thank you, Your Honor.
Away. Yes. Get where is?
That's all.
Bellinger
Yes, Your Honor.
and counsel on this one approach. Who's on the other side of you?
That's gonna be Ms. Feltis.
Oh. Don't question me when I get to tell you something. You know what, Alan? Don't say sorry. Court calls case People versus Enrique Davis.
Justice Phillips for the people.
And good morning, Your Honor. Assistant Public Defender Alexis. With and on behalf of Mr. Davis, who should be appearing on Zoom.
Yes, Eric Davis.
Okay, Eric Davis. All right, he's here.
And Your Honor, I do have a green sheet. We're just asking for a brief adjournment to continue some discussions with the prosecution.
May 14th, 2026, 9 a.m. Bond continues.
Your Honor.
Thank you.
Thank you.
Thank you, sir. Court does call the case People versus Michael Moore.
Morning, Your Honor. Raymond Cook with the people.
All 5 cases.
Yes.
Oh, you got to be on that side.
Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Moore. Would you?
Your name, sir? Spencer Moore. Thank you. What are we doing?
Your Honor, Mr. Cook indicated today that there will be new additional charges authorized as to Mr. Moore. So there are more cases coming. And we have been talking about trying to work out a global resolution. So we'd asked for a short adjournment in order to have those cases track. Yes.
Okay. Mr. Cook.
I see 2 additional requests in the queue. I'm planning on getting those reviewed tomorrow morning, so shortly here. I did also just want to clarify, I believe that there may have been a stipulated order for release to treatment. Does the court have that? I don't know if that was submitted yet or if that was.
And
I don't think I have that.
I believe that a stipulated order was submitted by Miss McGee when we were in court last time. But if Your Honor does not have that, I will look into it again. And I will double check. I did work on one with Mr. Childers for the first case that he had.
So it may be one, but not covering all cases.
The only reason I bring that up is I was checking XGL. I do see he has out of county holds. I'm not sure if that's going to affect his release to treatment.
Got it.
Because I see, I believe it's check here, Dieter Warren. There's a hold for another larceny from a motor vehicle there.
probably gonna be a problem because I'd be releasing him on a PR to treat with a tether.
I will have one of our paralegals see if we can resolve that outstanding warrant. They've had good success with that in the past.
Yeah,
Yes, they have. I'm really impressed with what they've been able to do.
your interns?
Well, I'm sure the interns could too, but the paralegals,
Oh,
a couple of them.
I don't like any of your paralegals. Just thought I'd say that out loud. All right.
Let me know.
You're welcome. Other charges that are coming. I want to give a date so we can try to get everything together for this gentleman. If I put it out 2 weeks,
I'm going to try and get them reviewed and either have a decision tomorrow. I don't know how long.
Okay.
Officers to come in and swear to the new charges, if any.
okay. If we can get those done, then get him arraigned on those.
2 weeks should be fine.
Thank you, Ms. Fount. All right. I will adjourn these then to May 7th.
Thank you.
Right. Thank you. Court calls the case, People versus Phillips. Patriceio.
Your Honor.
Your name, sir?
Phillips Patriceio.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. D. Patriceio.
What are we doing?
Your Honor, I do have a green sheet for this matter. We are asking for some additional time for investigation and ongoing discussion with the prosecution. We would also like to address bond.
We'll adjourn the matter to May 14, 2026. All right, Esteban.
Your Honor, Mr. D. Patriceio is on a GPS tether, and we are asking if the court would consider removing the tether. Since he has been on tether, there have not been any violations. He has not gone to the hotspot. This is his first, it's my understanding, this is his first contact with the criminal justice system. He is asking that have the ability to, in addition to being able to have the tether removed, that he would also.
Who's the alleged victim to him?
I believe it is his former partner, the mother they have a child in common. And he is also asking that they be able to have some contact as with regard to the child in common, no other contact.
Is there a divorce pending? What's going on?
My understanding is that there was a messy divorce with
There was a what?
a bit of a messy divorce, but that I believe
And after that
finalized.
came out?
Pardon?
Yeah.
Yes.
Okay. And so there's messy divorce. These charges come out and you want me to remove the tether.
That is his request, Your Honor.
All right. Response.
This is the second, count on this, and the first, you have aggravated assault, or aggravated stalking in the past, which was dismissed, and the contract had continued. They previously had, some contact in regards to, however, he violated that, and so that was removed. They would speak about the children, but then also speak about other things. The victim has expressed that she's extreme emotional distress, and that she feels problem from the type of communications that he with her. So at this time, we the remain as well as the no contact and no go to.
Anything else?
Just for clarification, Mr. Patriceio is saying that he has not had any contact with his former partner, that any contact he has had has been with his daughter. And it's my understanding that in the divorce decree, that there is contact permitted for the purposes of visitation, other like that with regard to his daughter. So that is all, those are the only two modifications he is requesting. He has no prior convictions. Is that right?
Well, you're requesting a modification to take off the tether.
Yes.
Really what you're asking.
Yes. And he spent 3 days in jail on this matter already. So he is very, very sure that is not a place he wants to return.
Given all the circumstances, motion for bond modifications denied. I'm going to leave everything in place. So his bond will continue. We'll see him on the 14th. Thank you.
Thank you, Your Honor.
Thank you. Court calls the case People versus Angeles Warren.
Joy Gaines, Senior Assistant Public Defender.
We need help.
Okay, fine. I'm so
Gaines, Senior Assistant Public Defender, representing Ms. Warren. Your Honor, when we were before the court last time, Miss Warren was in the Wayne County Jail and we're not aware of that in time enough for her to
have not signed in. I think there was a writ and everything done. They just haven't.
That is correct. I have no explanation for her whereabouts.
I'll adjourn it to May 7th, 2026, 9 a.m.
Thank you.
Some cooperation. Thank you.
Okay. Oh, dear. Hey.
Calls the case People versus Jaquia Dunlap.
Your Honor, for the people.
But the floor sheriff Easter, defender on behalf of Jaquia Dunlap. I've called that name in the courtroom. Just don't know if
This
they're on Zoom or
courtroom
not.
moment turned intense because the judge completely lost patience. A defendant stood there insisting he did nothing wrong, denying every accusation, even as the court explained the violations clearly. The issue wasn't just what he did, it was how he handled it. Instead of listening, he kept interrupting, arguing, and refusing to follow basic instructions. The judge gave him chances to speak, but also expected respect in return. And when that respect wasn't there, everything changed. Because in court, attitude matters just as much as actions. Then came the turning point. The judge pointed out that the defendant wasn't just accused of violating conditions, he was also trying to get around them, using indirect contact when it was strictly prohibited. And that's when the line was crossed. Without hesitation, the judge made a strong move. His phone privileges were revoked immediately. No more calls, no more messages, just silence. Because the court believed those calls were being used to interfere with the case itself. And even as the defendant kept arguing, the judge shut it down with one clear message: respect the court or lose your privileges. So here's the real question. When someone refuses to listen in court, are they defending themselves or making their situation worse? Like and subscribe for more real courtroom moments.